team of lawyers there who advise on issues relating to housing and buildings. So broadly, policies to do with trying to provide increased supply of housing, legislation around how we deal with homeless people, how we allocate social housing, so people who are on housing benefit and such like. And then also things to do with how buildings and houses are actually built, so the standards to which they must meet for perhaps fire safety or other such things, so that they not only don't fall down, but also, particularly nowadays with the sort of green agenda, that they are energy efficient and are not causing increased carbon emissions. So that's what I do as my normal day job, but I'm also Deputy District Judge in the County Court. Now, the County Court is the civil side court system, so it is involved in resolving all sorts of disputes, but not criminal cases. That would be dealt with in the Magistrates Court, and the more serious ones in the Crown Court. The other side of the scale is the civil side, the County Court and the High Court, and they resolve civil disputes. So broadly, the sort of things that I would be involved in would be contract claims, someone who's bought something wasn't good enough, or didn't come up to the standard, someone who got some work done by someone who wasn't good enough. I could be dealing with personal injury claims, someone who's involved in an accident, it was someone else's fault, and they're bringing a claim because they've suffered an injury. It could be dealing with housing cases, so people who are private landlords or social landlords who are seeking to recover rent from their tenants and or possibly evicting from their homes. Again, also people who have mortgages and fall into arrears. Mortgage companies will go through the courts to try and recover possession of that property and or get some sort of payment schedule agreed so that people can stay in the property. And we also deal with family cases, so disputes when people get divorced or civil partnerships split up. We only deal with I only deal with financial elements of that. I wouldn't get involved in cases involving children and would need to resolve issues around children when their relationships break up, and other judges in the court system would. So fairly wide range of cases that we resolve, and they can range from anything from a few pounds to upwards of £50,000 to £80,000. It slightly depends, but and then the bigger cases that are up in sort of hundreds of thousands or millions of pounds would probably be dealt with in the High Court, which is just a higher level of judge that's dealing with. How did I get there? Well, I started and I did a law degree at Leeds University, and then when I finished my law degree I went to College of Law in Guildford to do a 1 year, at the time I think it was called Law Society Finance, but it was an exam, a course that I had to do if I wanted to become a solicitor. If I wanted to become a barrister, which is a separate part of a separate profession of law, I would have had to go to bar school instead of law school. So I did a year at the College of Law, and then to qualify as a solicitor you need to do a training contract for 2 years, and that's working in a firm of solicitors for 2 years. And I did that with a small firm in the West End of London, and what that firm dealt with broadly was all sorts of aspects of civil litigation. So I was either bringing claims on behalf of people or defending claims on behalf of people, often in the county court, quite often in the High Court as well. And I did that for about 8 years before I then took a job in the government legal service. And I took a job working for the department, well, it was then called the Department of Trade and Industry, it's now called the Department for Business. Vince Cable is the current Secretary of State of that department. And in the government legal service, people are encouraged to move around after 3 or 4 years in post. So I've done a number of different posts in that department. I joined there in 2000, and then in May of this year, I joined the Department of Communities and Local Government. So I've had a number of different roles across the government legal service. I started off post where we were investigating companies that were potentially defrauding people, and that could range from quite small-scale companies that were perhaps selling services that were simply non-existent, to quite large companies. There was a number of high-profile investigations, including the collapse of MG Rover, the car maker, and you might have heard just not that long ago, a few years ago, there was a company called Fairpack that used to, it was a sort of savings plan for Christmas, and collecting people's money and saving it. Unfortunately, it didn't save it very well, and lots of people lost a great deal of money. There was an investigation into why that had happened. And then I've dealt with, before I came to my current role, the last couple of things I was working on was the privatisation of the Royal Mail, which happened this year. So there's a lot of legal work required to put that into effect. And in terms of a sort of typical day as a government lawyer, difficult to sort of say what is a typical day, but I'll try and give you an overview of what I have to deal with, and broadly it's about advising government ministers about whether or not they have the legal power to do what they want to do. So government law is really all about the law of power. If you think about government, it's the sort of crown, if you like, in the UK is split into three things. There's the legislature and parliament, so that's the House of Commons and the House of Lords. Then there's the judiciary, so there are the courts that operate the law and make decisions based on the law. And then there's the government, and that's the government of the day, who are obviously elected. Now they principally are people who can bring forward changes to legislation, and what we advise about is whether or not, if they want to do something, for example, with the Royal Mail, and privatising the Royal Mail, there was legislation that said that that couldn't happen. It had to remain in public ownership. So in order to privatise it, we needed to have legislation changed so that it could be privatised. And that means presenting a bill to Parliament, and we will have government ministers in the House of Commons and the House of Lords who will take that legislation through Parliament and seek to persuade Parliament that they should vote in favour of it. And we're advising not only on the drafting of that legislation, but also on how the debates go in the House of Commons. We would sit there, although you won't see us on television, outside the line of sight of the cameras. We sit there scribbling notes to hand up to our minister so that they can answer questions that are put when the debate's going on. So really, as I say, what we're trying to do is make sure that government acts in accordance with the law, and if it doesn't, there's a route of challenge to the courts that people can bring. We call it a judicial review paper. It's where the courts look at what government have done and they decide whether or not they've got the legal power to do it. And assuming they have, they also have to decide whether or not they've acted in a reasonable way. As the government minister can't just decide, I want to do something because it's going to be helpful to where I live or something like that. He needs to act, he or she needs to act in the public interest, and needs to make sure that in decisions they take, that they are not influenced by factors that they shouldn't be taking into account, such as their own personal circumstances. They should be making those decisions based on objective factors that they can reasonably take into account. And so we are, every decision that's taken is considered quite carefully to make sure that it's as robust as possible in terms of withstanding any legal challenge. And we are frequently faced with legal challenge, some areas more than others. So, for example, for immigration cases, there are constant source of legal challenge being brought by people who not unreasonably wanted to challenge the decision that might have been made about whether or not they can either come to this country or remain in this country. So that's sort of really what government law is all about. We're not spending the whole time drafting legislation. We advise on existing legislation or represent any legislation to Parliament. We need to be able to say that it's compliant with the Human Rights Act, so that insofar as it might be interfering with people's human rights, that there's some proper justification for that. And there are some rights, of course, like the right to life, that you can't interfere with at all. But most human rights are what we call qualified, so you can interfere with them if there's a legitimate reason to do so, justification. But then you can only interfere insofar as it is necessary to achieve what you're trying to do. So it's not a sort of carte blanche to just go and override people's human rights, and we spend a lot of our time analysing what rights might be involved and what sort of arguments might be put forward to justify an interference in some rights. And then as a judge, my sort of typical day is I will go and sit in county courts within the M25, so within the sort of London area. And it really depends, different days I will have different court lists. Some days I might be dealing with one trial, and it will take me a day, and I will hear the evidence from both parties and the arguments, and then I have to make a decision and give them that decision and explain why I've reached the decision I have. And the difference between my role in the civil courts and in criminal courts is that in criminal courts, generally it's a jury that would decide the facts, so they decide who's telling the truth. And there, the test that they have to be satisfied with, we call it beyond reasonable doubt. And the burden of proof is on the prosecution who are bringing a criminal case to prove beyond reasonable doubt that what they allege happened. In the civil courts where I sit, the burden of proof is less than that. It's not beyond reasonable doubt. We call it, it's on the balance of probability. And what that means is it more likely than not that the case that's been brought by the claimant in a particular case, is it more likely than not that what they allege is true? And there's no jury to decide those facts. That's for me to decide based on the information that's put before me. It might be documents, it might be evidence from individuals who are telling me, for example, what happened in a car crash, who was driving there. Often those sort of cases are very difficult because often it's just one person against someone else's work. And if I'm not sure, the burden of proof in civil cases is on the person bringing the claim. So they have to satisfy me, and if I'm not sure, if I think it's sort of 50-50, then I have to decide in favour of the person defending the claim, because the person bringing the claim hasn't proved in the balance of probability more likely than not that their case is the one that I should accept. And the different so I could be dealing with a day's trial. I could be dealing with what we call small claims, so claims that are below £10,000 go on a procedure which means that people can have them determined often in quite short periods. It might be an hour to 2 hours, and the benefit for them is that they don't, if they lose, they don't have to pay heavy legal costs of the party who they've brought their claim against. And so it's a more informal way of resolving disputes. But it's quite challenging because most of the time the people bringing those claims are doing so without the help of lawyers. So often I'm trying to explain to them what the process is and make them understand that today, if it's the final hearing of their case, I have to make a decision one way or the other. And I can only do that if they are able to explain to me clearly what the nature of their case is and what the issues are in dispute. And I think, for me, that's an important fact to bear in mind to any sort of legal work, is that the key skills of lawyers, I think, are about communication and how you present information, because some people will have piles and piles of documents and we'll be talking about lots of things that are actually not really very relevant to the issue and dispute. And the people who can narrow it down, focus on the things that are really important, and present that in a very accessible way, a very easy way, makes my job a lot easier.
and means that actually you focus on the things that are important. So it's the same as a government lawyer, and indeed a lawyer who's just acting as I used to when I was in what we call private practice, acting for individuals or companies. It's all about trying to present your case in the best possible way, and in a way that is quite succinct, and you pack all this information into quite a relatively confined statement, concise statement. So the sort of typically there, as I say, as a judge is dealing with any number of cases. The first day I ever sat as a judge, I was obviously a bit nervous, and I had a list of 55 cases, and I worked out that each one was listed for 5 minutes, and that was going to take me from 9:30 in the morning to 4:30 in the afternoon. And you think, well, that's not that long a day, but actually when you've got to make 55 decisions, you've only got 5 minutes to do so. Now, we're not talking about decisions on big cases. We're generally, in those instances, we're talking about decisions on cases where you're trying to move the case on to the next stage. When people start that case, the court's job is to get it ready for someone to finally determine this. And sometimes that means that the parties need to share with each other the documents that they might want to rely on. They might need to share with each other the statements of the witnesses who they intend to rely on. So then we call that case management, and there's quite a big role for us to play in ensuring that cases are dealt with quite quickly, that people can bring a claim, and within, well, I mean, it used to take an awfully long time. It's getting better, but it could still take 6 months to a year before that claim is ready to be heard by a judge. And part of that is getting a slot and time for the judge to hear. There are only so many judges, there aren't really enough to deal with cases as quickly as people would perhaps like. So that's part of our challenge. So the day judging is nothing's a typical day, and I don't actually find out until I turn up at the court what it is that I've got to do. And I generally try and get there early so I can read as much as I can about it. Now, I was asked if I could tell any amusing tales, and I think lawyers are a bit funny because they'll probably always think that things are amusing to them, and actually to lots of other people they just won't see the funny side at all. I was told by a judge once that he had to deal with a claim which someone brought where they were complaining about the quality of the pizza that they had ordered. And the pizza, I think, had cost them £12, and they'd spent £50 bringing their case to court. And the judge was a bit puzzled by this, and also he couldn't really understand how he was going to decide whether the pizza, which the chap had bought, I think 6 to 8 months earlier, was really a satisfactory quality. I don't envy him having to try and explain why it is that it's probably not really a good use of the court's time to resolve a claim over a pizza. But then again, some of the cases I've had have been for £100, £150, and to me that's a lot of money, and to many individuals that would be a lot of money, and if they're dissatisfied, they want to try and get their money back. But the sort of, I think for me, some of the more amusing things are sometimes what you see in what I describe as the sort of theatre of the courtroom. And if you've never been in a courtroom and you're interested in the law, I would strongly recommend that you go. They're all open to the public, so any court you should be able to go into and see virtually any case. There are some that will be held in private. The vast majority will be open to the public. There is somewhere where you can sit and you can just observe cases that are going on, be they the county court, the crown court, or the magistrates' court. I was also asked if I could say something about some of the biggest cases that I've dealt with. And some of that, I mean, it's quite difficult to know. In terms of money, I'm working on something at the moment that's involves just upwards of £500 million, so a lot of money, but then lots of things that government do involve large sums of money. The sale of the Royal Mail raised somewhere in the order of £2 or £3 billion, although there's a lot of failed to ever get the case went that long. And part of the difficulty in that case was one of the defendants, who actually I think was the main fraudster. He was not legally represented. He'd been on legal aid and then they'd taken that away from him. And that added substantially to the time that it took, because he wasn't able to, normally for lawyers would be able to focus on the key things that need to be decided and direct the judge to what needs to be decided, and that wasn't possible. But we did have 90 days in court. You can imagine the amount of money that racked up in legal costs, and in the end, I think we succeeded actually. We recovered from the other side about £1.5 million in legal costs. That's not a large sum for a case of that sort of size. And that case involved an allegation where my client had been trading, he'd been buying and selling things like shampoo, soap, deodorant in vast quantities. And he'd been trading with another businessman. And he'd done some deals where he'd sold things and the money had come in. And then they started to build up quite a large debt. And then eventually this debt was eradicated by one massive transaction they did for a quantity of leather goods. And when it came out in the paper when the trial started, it was described as 32 double-decker buses worth of leather goods. If you can imagine 32 double-decker buses lined up, that was apparently a quantity of leather goods. And most of it was either out of date. There were lots of things, passport holders, passports that we used to have 20 odd years ago, but we don't know, but much smaller size. And lots of the goods were of poor quality. Anyway, this was the fraud that we were involved in dealing with and investigating. It takes an awfully long time for people to actually analyse the information. So you can imagine in that case you have reams and I'm just looking at some shelves here. We probably had at least 2 of these shelves full of legal arch files of documents. And some poor lawyer, in this case me partly, was having to actually look at each one of those documents. Lots in the rear, but in amongst some of the documents there were really key things that are actually important records of what happened. And there's no better record than a record made at the time that you might then be relying on years later to demonstrate something happened. There's no better record than actually having made it. In terms of sort of moral and ethical issues that we have to deal with, I've already mentioned Human Rights Act, and that's something that we deal with all the time. The question I think most people ask lawyers is, how can you defend someone who's guilty? And actually, I think it's quite easy to answer, because you're looking at a criminal case. I mentioned before that the burden is on the prosecution to prove that whoever it is committed this offence. The lawyer defending the defendant, if the defendant says to him, look, I did it as well, then that lawyer can't try and suggest to someone that he didn't commit the offence. What he can do is challenge the evidence that the prosecution are relying on. So if they're relying on someone who apparently saw us carry out the offence, they can challenge that and perhaps very closely on could they actually properly see that sort of thing. So, and what the defence lawyer is doing, even if he knows his client's guilty, and most defendants wouldn't actually admit to that anyway. But even if he knows his client's guilty, what he's doing is making the prosecution prove their case. They have to prove their case, and there are many cases where the prosecution probably know that someone's committed a crime, but they might not have enough evidence to actually prove that. And as lawyers, we're also under a duty not to mislead the court, so we can't do things that would in some way implicate us with our client's offence. So it's not about winning at all costs, it's about professional responsibility not to mislead the court. And as I say, if a client tells you that something happened, you can't try and persuade someone else that it didn't. But mostly clients, certainly in the criminal sphere, I think most criminal lawyers will tell you that their clients are quite knowledgeable about criminal courts, and they know that really they shouldn't be telling you, oh yes, I did it. But if that happened, then you can still, your advice to them would probably be based on the evidence, and perhaps you should admit your guilt, and you'll be given a lesser sentence because of that. But it's still possible, and lots of lawyers will only represent defendants. They see it as their role to ensure that the prosecution actually prove their case. And although there have been miscarriages of justice in the past, and they are generally quite high profile, I would have thought in the vast majority of cases it's more likely that someone who has committed the offence is going to get off and not be convicted than a situation where someone who hasn't committed the offence is completely innocent, is wrongly convicted. It has happened, but it is extremely rare. The system is designed so that that shouldn't happen, and any system is found. And the other sort of big moral, ethical issues, I guess, that government come across, how we balance people's human rights. I mean, there have been cases recently about right to life and the right for someone to be able to die. Can someone who's terminally ill and can't help themselves, can't kill themselves, can they ask someone else to do so? Can that person help them without being able to murder? And where the courts are relying at the moment is to say, well, no, you can't do that. You can't get someone else to help you. That would be wrong. And actually, like the courts have said, it's for Parliament, it's for the legislation to be changed to make it possible, if that is what society wants. And that's where politics comes into it, and the politicians are. And I don't actually think politicians, I mean, if you actually try and analyse it, it's incredibly difficult to think about how you could legislate to allow someone to kill someone else. So that's the sort of issue you grapple with. And another one that you might have been reading about is prisoner voting rights. So should prisoners be allowed to vote? There's a court in Strasbourg, the European Court of Human Rights, which is the ultimate court that people can appeal to if they are concerned that their human rights have been breached. And that gave a ruling against the UK government that has a total ban on prisoner voting. And I don't think the government have yet worked out how it is they're going to respond to that. But they need to, to grapple with how can we give some prisoners the right to vote. And of course, lots of people think, well, they shouldn't have it. But the Court of Human Rights has said that that is not a position that the UK government can continue to maintain. Terrorism is another area where all sorts of problems come to the fore, particularly in terms of human rights and rights to fair trials. And people who've been locked up in Guantanamo Bay, which is some sort of odd place in Cuba that's a bit of an American base, but the rule of law just doesn't really seem to operate there. And some people will think, well, hang on, if this is about terrorists and trying to prevent people carrying out terrorist attacks, then it's okay to be able to lock them up, even although you can't prove that they've actually committed any offence. And here we have issues about how long can we detain people without being charged. And ordinarily, there's a strict rule about you can only be detained without being charged for a relatively short period of time. And after that, the police have to decide whether to charge you or to release you. And it's right that you shouldn't have your freedom taken away from you without some sort of fair process of having a trial where someone can actually determine whether or not they're guilty of the offence and should be punished. So we come across those sort of issues all the time, and they can come up in all sorts of different areas. they want to be a solicitor, they want to do another year's course. So that's perfectly possible. I would suggest that you go and experience the law in practice, see if you can get some courts, see what goes on, go and see if you can get any sort of work placements, that sort of thing. But also, don't. I think the best lawyers are the people who are actually the most rounded, who've got other experience as well. So, and I know lots of people who've done certain jobs and then decided to convert and become a lawyer, maybe slightly later in life. So I don't think you necessarily need to single-mindedly follow a path of the law. And if that's something you're interested in, then yes, absolutely go and do it. But for me, it wasn't until I started working in the law, being a lawyer, that I actually began to understand and realise that I enjoyed that. I met other people who didn't. They liked the idea of studying it, but they didn't actually end up enjoying it in practice. And it can be quite challenging, quite stressful sometimes. You're often dealing with people who are, in difficult situations, be it criminal law where they're being prosecuted for offences, or perhaps civil law where they've been maybe some sort of dispute resolved. You're often dealing in quite extreme situations, and it's not always easy to handle people in those sort of circumstances. But yeah, in terms of sort of preparation you can do, I think try and get as much information and experience as you can about what lawyers do, because there's a whole range of things. Your sort of criminal lawyer who is representing people in the magistrates' court every day is so far removed from your city lawyer who earns hundreds of thousands of pounds working on huge multi-billion pound mergers and acquisitions. There's a world apart between what those people do. And when you choose to go into the law, there's pressure on you to specialise, because you can't know it all. There's absolutely no way that you can be an effective lawyer at everything that goes on. So there is pressure on you to specialise. And I think before doing that, you need to have an idea of the sort of different things that are out there and what might interest you and what you might be good at. So I probably talked too long, but it'd be great to have some questions and really anything to do about law or politics as well, because that's something that we have to deal with on a daily basis.
Okay. Any questions? Okay, Adam?
Realistically speaking, does somebody of your position have to be impartial?
Yes, so I'm a civil servant. That's what we're called. So, and we have a code that governs what we do. And although I'm allowed to vote, and I've got political views, but in my work, our primary duty is to give impartial advice to our ministers. So we can't try and advise something that we want to happen. We have to give advice to them that's completely impartial and independent, and that's what all civil servants sign up to.
So do you choose which ministers, which parties you want to give advice to?
No, I have to give advice to whoever is in power on the day. So for me, I advise the public ministers and local government, so it's the ministers who are there, and they chop and change from time to time as the government decides, as the Prime Minister decides to reshuffle his senior teams. No, I can't choose who I can give advice to or not. What I can do sometimes is if the government minister wants to do something that would be unlawful, then first of all I have to tell him or her that. And if they still wanted to proceed, then I'd have to involve other people, ultimately the government's chief legal officer, someone called the Attorney General. And he would have to step in and say, well, actually, legally you cannot do that. That would have to be stopped. So, to that extent, I suppose I can tell people occasionally that they shouldn't do things. But mostly it's giving them a risk-based assessment. So they might want to do something. It might be legally possible but highly risky. And as long as I outline to them those risks, they can decide, and it's for them to decide whether or not they want to take that particular step.
Right?
With much of our sort of sovereignty moving to Brussels, and Brussels sort of having the last say on a lot of domestic legal cases. What is your view, sort of, from the legal profession about our membership in the EU?
It's a very good question, and actually European law is something that we deal with a lot, and as you say, there are aspects of our law where it comes from Brussels, and our obligation as a member of the European Union is to ensure that that law is put into effect, and that's very problematic actually from my perspective, because certainly the current government, parts of the current government, are not particularly in favour of the EU, and so they're not very happy when you say to them, well, we have to do this because European law says, and they often say, well, why? Do we really have to do it? And you can get into sort of issues there. What do I think about the European Union? I think the idea of it was to have a sort of proper free market of goods and people, so that people could move around in the Union and that goods could move freely around the Union. And I think from a business perspective and the economy perspective, that's a really good thing. I used to work in an area where we dealt with safety standards for various different types of products, so I think it's important that, you know, if products are being imported from any part of the European Union, that they all meet certain standards so that they're safe, depending on no matter what they might be used for, so that they don't cause injury to people. What I am more sceptical about is areas where it starts to sort of become broader than that. And I think that's the worry about the European Union, that they're trying to infiltrate in areas where it wasn't originally intended. And, you know, it's very difficult. It's a very political issue. For us as civil servants, it's something that we have to be aware of, and we can't allow the government to act in breach of European law. But it doesn't cut across every area of law that we deal with. But it is, you know, it's a very big political issue, and I mean, I believe there's going to be a referendum at some stage about whether or not to stay in the European Union, and it'll be very interesting. It'll be very interesting if everyone decides not to. How we extricate ourselves from it, and I think from an economic perspective, it would be a bad thing, but I can see why some people, you know, and there's lots of rhetoric about it as well. I mean, particularly at the moment about Romania and Bulgaria joining, and the fact that there might be flood of people coming to this country. Well, actually, you know, the reality is that you can't. The people who are allowed to come because of membership of the European Union are people who want to work, not people to just come here and, you know, claim benefits or whatever it may be that you hear the politicians talk about. They're only really allowed to come to work. And, you know, history shows that we as a nation have had lots of people come in and out, helping our economy, and across Europe, you know, we can travel to other countries and work there. So I don't myself have a particular problem with that, and sometimes the politics of it all rather takes over what I think the reality should be. But nevertheless, you know, you can understand why people might have concerns. And, you know, some areas see it more than others. London probably much more than, say, if you were living somewhere deep in the country where perhaps you wouldn't sort of see that on a daily basis.
Any more questions? Okay. I have a last question. From a judge's perspective, obviously there's been a lot of kind of constitutional reform to make the judiciary more independent. Do you think that's gone far enough, and if so, how effective has it been?
I think it probably has gone far enough, and the judiciary were always independent. I said part of my talk that we have the judiciary, Parliament, the legislature who pass legislation, and the government, and that's the sort of three things that make up the crown. The Queen sits at the top, but it's very much a sort of figurehead position rather than a decision making. The problem with the independence of the judiciary partly stemmed out of the fact that the highest court in the land used to be the House of Lords, which is also part of the legislature. It's part of Parliament. So the problem was, how could you have judges who are meant to be interpreting the law also be making the law? And so the way they dealt with that was to create the Supreme Court. So the Supreme Court judges, they're the highest judges in the land, but they're not entirely judiciary. I think as a sort of legal concept is there, and it's absolutely crucial, and all judges will be very aware of the need to remain independent, and not only to, it's about people's perception as well. I mean, it may be that you think as a judge, well, sometimes I've had to actually turn cases down because I've either known, one I had was the law firm that I used to work for on one side of the case, and someone suggested that I should not deal with that case because someone else might think that I would in some way be favourable to the law firm that I used to work for. So even though I wouldn't dream of doing that, the fact that it might be a perception of people was important that I then didn't deal with that case. So yeah, the independence of the judiciary is crucial. I'm not sure what more we can do to sort of make that any realer than it actually is. I think all judges are, but every now and then there will be cases where people feel that a judge has been biased, and there have been cases where that's been successful. And it's about, it's about the appearance of it. You want people to know that there's no possibility that someone could be biased or influenced in some way by things that they shouldn't be. So I think the judiciary is okay as far as independence goes.
Okay. Well, thank you very much for coming. Can we give you've eaten a huge chunk into your enrichment, but if anyone is doing enrichment on site, please feel free to attend the rest of it. And also, LawSOC tomorrow, we have our mock trial, so I'd love to see you guys there also. Thank you very much.